What's up, everyone out there in YouTube world, Facebook world, social media world, the world? Welcome to another episode of Musings with MGL. I'm your host, MGL. So let's just get right into this. Of all the things that I would be talking about, or I thought I'd be talking about today, Alec Baldwin's criminal charges being completely dismissed was not one of them. That's right. In case you haven't heard the news, Alec Baldwin's manslaughter charge was thrown out today by a judge. So, why, you might ask? Well, let's find out. Alec Baldwin weeps in court as judge announces involuntary manslaughter case is dismissed mid-trial. Santa Fe, a New Mexico judge on Friday brought a sudden and stunning end to the involuntary manslaughter case against Alec Baldwin, dismissing it in the middle of the actor's trial and saying it cannot be filed again. Judge Mary Marlowe Sommer dismissed the case based on misconduct of police and prosecutors over the withholding of evidence from the defense and the 2021 shooting of cinematographer Helena Hutchins on the set of the film Rust. Baldwin cried, hugged his two attorneys, gestured to the front of the court, then turned to hug his crying wife, the mother of 7 of his 8 children, hold the embrace for 12 seconds, blah, 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 who gives a shit. The late discovery of this evidence during the trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings, Marlowe Sommer said. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith to show signs of scorching. The case-ending evidence revealed during testimony Thursday was ammunition that was brought into the sheriff's office in March by a man who said it could be related to the Hutchins killing. Prosecutors said they deemed the ammo unrelated and unimportant, while Baldwin's lawyers alleged they buried it and filed a motion to dismiss the case. The judge's decision ends the criminal culpability of the 66-year-old Alec Baldwin after a nearly 3-year saga that began when a revolver he was pointing at Hutchins during a rehearsal went off. Our goal from the beginning was to seek justice for Helena Hutchins, District Attorney Mary said. We are disappointed that the case did not get to the jury. So, as a lawyer, let me try and explain this to you real quick. Prosecutors have a duty to disclose all evidence in a case. So if you have a criminal case, there's something called discovery, which means the prosecutors are supposed to turn over all the evidence that they intend to use in the case to the defense attorneys. The defense attorneys then get to go through that evidence. The defense attorneys then get to go through that evidence and then be fully prepared for trial. It's basically fairness. If the prosecutor fails to turn over evidence, you can file motions to dismiss. Now, that happens all the time, quite frankly, in probably 50 to 60% of my cases. Late disclosure happens. I once had a case where I got a DNA report 3 days into the trial. We picked a jury on Monday and started the trial. On Wednesday, I got handed a DNA report regarding a shooting case that I had. Now, I moved to dismiss the case and or at least have a mistrial. It was denied, and I won the case anyway. So the guy was found not guilty, so it worked out in the end. However, what I can tell you is that happens all the time. You get discovery right before trial, you get discovery in the middle of trial. It happens all the time. Here in Florida, the standard is basically, what's the remedy? So dismissing a case completely, especially with prejudice, which means you can never bring it back again, is the most extreme remedy you could get for prosecutorial misconduct. Needless to say, because it's the most extreme remedy, they don't usually do it. Like, I've never, quite frankly, seen a case in Florida thrown out due to late disclosure by prosecutors or prosecutorial misconduct, because they figure what you can do is you can just declare a mistrial, continue the case for 4 weeks, allow the defense attorney time to get the discovery and go through it and then properly prepare for trial, and then you just do the trial again. So there's all kinds of things you can do to remedy the prejudice to the defendant that doesn't involve just dismissing the charges completely. So that's why here in Florida, like I said, it rarely happens. It's almost impossible to get a mistrial. Like the other trial I had, something happened in court that was sort of a late disclosure, and the judge basically told us to go in the hallway for an hour and re-prepare our basically entire case based on the new evidence that came out in court, and then we started over again. That case is up on appeal because I don't think the judge should have done that. So judges down here, they don't throw out cases. They tell you to go out in the hallway and basically get prepared, or they'll declare a mistrial and continue the case and have you come back again. So the fact that this was thrown out completely, either in the state where this was occurring in, is way less allowable for prosecutorial misconduct than the state of Florida is, or perhaps prosecutorial misconduct was obviously really that bad. Based on what I just read in that article, it doesn't sound like it was that bad. Somebody came in with ammo again, you could just declare a mistrial, continue it, and do it over again. Unless maybe there's speedy trial issues or something. But for whatever reason, the judge out there thought that it was misconduct. Now, the only time that I would say that you could probably get it thrown out is if it has to be, again, real misconduct. Most of the times it's just laziness by the state attorney's office, and they just forgot to turn it over because, again, they're just lazy. But if you have a case where a prosecutor, let's say, has evidence that somebody is innocent and they hide it or they bury it, that I could see rising to the level of prosecutorial misconduct that would possibly get the case overturned. However, I still feel in Florida, based on doing this for 20-something years, that they wouldn't do that. They would kick the prosecutor off the case, maybe disbar the prosecutor or something, but they would just declare a mistrial and do it over again. So the fact that they threw that out completely in this case it's a pretty extreme result, whether it's the right one or the fair one. I wasn't there for the whole thing. I don't have all the information. It seems pretty extreme to me that's what the result would be based on what I just read about the prosecutorial misconduct. But by the same token, I'm telling you, prosecutorial misconduct happens in almost every case that I have, where you can't get discovery, you get late discovery, there's surprise witnesses, there's surprise photographs, there's surprise DNA reports. I mean, it just happens all the time. And maybe if they started throwing out more of these cases, then prosecutors would be less inclined to do it. But the fact of the matter is, hey, after all of this, Alec Baldwin goes free. His case has been dismissed with prejudice, which means the Constitution kicks in where he can't be tried again. So it's over. His case is done. The saga's done. There's a civil suit, obviously, that either went through or is going to go through. But the fact of the matter is, the criminal charges against Alec Baldwin have been dismissed with prejudice forever due to prosecutorial misconduct. So interesting information. Thanks for following. Thanks for listening. Again, like, share, subscribe, comment down below what you think about it. If you think it was right, if you think it was wrong, if you think you would get the same treatment as Alec Baldwin would have got, that's an interesting question. So please do all that stuff down below. That's it for today. As always, thanks for watching. Stay safe, stay healthy, stay vigilant, and as always, carry on.